On December 16, 1965, in Des Moines, Iowa, 13-year-old Mary Beth Tinker arrived at her junior high school wearing a 2-inch wide black armband as a form of protest against United States involvement in the Vietnam War, and to show support for a proposed Christmas truce. The following day, her brother, 15-year-old John Tinker, along with several other students, wore similar armbands to their high school. The armbands were the subject of many comments in class, leading some teachers to complain that the armbands caused their students' attention to be pulled away from their regular lessons. However, no violent disturbances occurred, and other than the discussion the armbands caused among the students, the protest was silent and symbolic.
There was I think, an article in the newspaper that indicated that this was going to happen, and consequently, when the school held a meeting and announced that if the kids were to wear the armbands to school, they would be asked to remove them, and if they did not remove them, then they would be suspended and they wouldn't be readmitted until they agreed to remove them.
5 students, including John and Mary Beth Tinker and their friend Christopher Eckhart, were suspended from school. Their parents filed a complaint in a U.S. district court asking for an injunction restraining school officials from disciplining the students, but their complaint was dismissed. Unless the students agreed not to wear the black armbands to school, they would remain suspended until January 1st, 1966, the date the protest was scheduled to end.
Schools traditionally hadn't been thought of as areas where freedom of expression was broadly considered, at least constitutionally considered. Schools are there to teach you the 3 R's, to teach you that, in fact, the 3 R's aren't really 3 R's. There's only 1 R in the 3 R's. That's the point of schools, to teach you a set curriculum. They are not places of public debate and public discussion. And so there's a long tradition of deference to local school authorities, to principals, and to teachers in constructing the context of the school day. And so the district court just said, there's no case here. There's no case here. Tinker himself does not have a full panoply of First Amendment rights. He's a school student. So the parents appealed, the kids and the parents appealed.
Well, their argument was that we deliberately planned this demonstration, or this form of speech, in such a way that we believed would not distract from the educational environment. It was a silent protest. We weren't speaking. We simply were wearing a black armband, which people could look at and draw their own conclusions. And we think that that is a right that we have, that the school environment is, as long as we're not interfering with the school environment, we ought to be able to utilize our right of speech just like anybody else would in another environment.
The case went up and worked its way up to the United States Supreme Court. And you have, on the one hand, the notion that the principal ought to be able to run a school. And on the other hand, that kids should have a right to speak. And the argument was they weren't disruptive. They didn't say anything. They simply wore a black armband.
The case of Tinker versus Des Moines Independent Community School District was argued before the nation's highest court in November of 1968, nearly 3 years after the students had worn the armbands to school. The question before the court was this: did the policy prohibiting the wearing of armbands in a public school as a form of symbolic protest violate the students' First Amendment right to freedom of speech?
The question is this speech anyway? Because you're just wearing an armband, right? Speech, traditionally understood, if you say, I'm going to speak to you, you assume that there's going to be some verbal communication. But speech can be other. People make gestures on highways, which constitute speech, for example. In this instance, the only reason for wearing an armband, which is non-disruptive just generally, is to convey the idea that the armband embodies.
The primary argument that the schools made was, number one, the court should not be second-guessing us. We are the experts on school affairs and school disciplines. Traditionally, the courts have let us run our schools as we thought best, without a lot of supervision. And this is simply one more area in which, as long as the decisions that we make are reasonable, we should be left alone to run the schools as we see fit.
Well, that argument is rejected in Tinker. There was no indication that it was disruptive. And so the school board had a lot of trouble convincing the court. And the opinion by Justice Abe Fortas says kids don't lose their right to speak when they walk through the schoolhouse door. And the argument was they did have rights.
By a 7-2 vote, the Supreme Court overturned the judgment of the lower courts and ruled in favor of the First Amendment rights of the public school students. The majority ruled that, although there are implied limits to speech in a school environment, in this case, the school administrators did not prove that the symbolic protest of the students substantially interfered with the ability for the school to maintain discipline.
The state needs a reasonable basis that the speech will be disruptive and cause discipline problems. So in the absence of any reasonable evidence that the discipline or disruption will occur, then the state is not free to interfere with public political speech on issues of public concern or public policy. According to the court, there was nothing found by the district court that had any reasonable basis of believing that the armbands would cause disciplinary problems or disruptive of the school operation.
Justice Abe Fortas authored the opinion of the court. He wrote that the wearing of the armbands was closely akin to pure speech, which the Supreme Court had ruled many times falls under the protection of the First Amendment. He also wrote,
First Amendment rights applied in light of the special characteristics of the school environment are available to teachers and students. It can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate.
The two dissenting justices, Justice Hugo Black and Justice John Marshall Harlan II, disagreed. Justice Harlan wrote in his dissent that the school principals had acted in good faith when they established the policy against the wearing of the armbands.
The most wonderful dissent, because he was outraged, is that of Hugo Black, who claimed that this was judicial nitpicking, that judges had no role to play whatsoever in decisions about pedagogy and how you teach young children the material that they're supposed to learn in schools.
If the time has come when pupils of state-supported schools, kindergartens, grammar schools, or high schools can defy and flout orders of school officials to keep their minds on their own schoolwork, it is the beginning of a new revolutionary era of permissiveness in this country fostered by the judiciary. This case, therefore, wholly without constitutional reasons in my judgment, subjects all the public schools in the country to the whims and caprices of their loudest mouth, but maybe not their brightest students. I wish, wholly, to disclaim any purpose on my part to hold that the federal Constitution compels the teachers, parents, and elected school officials to surrender control of the American public school system to public school students.
The case of Tinker versus Des Moines was a landmark Supreme Court decision and is still cited today in cases involving the extent of students' free speech rights. However, this has turned out to be the last time public school students have won a First Amendment free speech case before the U.S. Supreme Court.
Tinker's important, I think, for two reasons. One, for the notion that speech can be symbolic, and that the wearing of an armband is a mode of expression that the state has to respect. Secondly, that school children, in the context of schools, have, to some degree or another, protection of constitutional rights, which include the right to free speech.
The legacy of Tinker is a bit hard to judge. On the one hand, there are definitely lots of lower court cases where the courts have upheld students' rights based on Tinker. But on the three occasions where the Supreme Court has considered disciplinary actions that were arguably in violation of Tinker, it carved out exceptions and upheld the school in all three of those. So looking at the cases that have followed Tinker, you might actually draw the conclusion that school regulation of speech has become the rule and Tinker is now the exception.